to me, he said, do you know how they catch spider monkeys in the bush? No, he said, they take a jar, like a big jar with a little narrow neck, and they put a bit of fruit in the bottom of the jar. The little spider monkey comes along and he grabs the fruit. He's got it in his hand, but he's got it clenched, but it can't come out through the neck of the bottle. All right. And that's like that fruit is his next meal. That's his security. But he won't let go of it for his own freedom. All right. And they just come along and pick him up off the ground, and away they go. And that was a valuable lesson. You've got to be prepared to let go of your security to gain what you really want in life.
Welcome to Get Invested on the Property Hub podcast channel, the leading weekly show for Australians who want to learn how to unlock their full self, health and wealth potential. I'm your host, Bushy Martin, and each week I go deep with the best investors, experts, leaders and founders to find out what it takes to break free from the grind, discover freedom and to live by design. Subscribe now and join me and get invested in the life that you really want. Let's get started.
Hi, freedom fighters. What's one of the biggest invisible risks to your financial independence, sustainable success, and your freedom? Think about this for a moment, because it may not be what you think it is. Now, you may be thinking that it's a major economic crisis like the GFC or another health pandemic. There's something that's much more personal and closer to home that has big potential to shipwreck your life and your financial plans when you least expect it and when you can least afford it. So what is it? Well, let me give you a hint by sharing that the love that two people have for each other is a beautiful and splendid thing. It's the foundation of trust, partnership, and a future built together. So imagine this. You and your partner are standing at the beginning of forever, full of hope and ready to intertwine your lives. You don't just dream of a future together, you're actively preparing for it. And an important part of that preparation means having all of the tough conversations now, while love is actually abundant, rather than in the painful aftermath of a breakup where emotional and hurt feelings will really cloud your logic. So have you guessed the big invisible risk that you face? Yes, I'm talking about the emotional, relational, health and financial risks to your wealth and your well-being of relationship separation. Because sadly, I've been there, and I can tell you that it's the worst thing that's ever happened to me. That has left deep emotional and financial wounds and scars for my son, my ex-wife and myself that have never really healed. And starting again with next to nothing when we ended up burnt out, broken in my 30s, has set us all back by decades with a trail of trauma. And clearly I'm not the only one, because here's some of the stats. While divorce rates have actually on the improve here in Australia, according to the Australian Institute of Family Studies, roughly 40% of first marriages still end in divorce, so about 4 out of 10 of us. And this only gets worse on the second time round, with the divorce rate for subsequent marriages ending up around 65% in divorce, or 2 out of 3. And that's a pretty big probability. Now in Australia, the current median duration of marriage to divorce is around 12.8 years, while the median time to separation is 8.9 years, which is not very long. And it's well below the 15 years plus that you need to hold an investment property if you're looking to achieve good results. So if you're married or in a long-term de facto relationship, then between 4 to 7 of every 10 of you that are listening now are likely to experience a relationship breakdown and separation at some point. Now, the median age of divorcees is currently between 44 to 47, with children being caught in the crossfire in 1 out of every 2 divorce cases. So starting again in our mid to late 40s can be devastatingly dangerous in terms of our financial positions and take many years and is very difficult to recover, with resultant declines in income, savings, assets, super and housing instability. So the truth that too many couples overlook is that while love is boundless, life is very unpredictable. So how do you mitigate and limit these devastating relationship breakdown risks? Firstly, by investing heavily and regularly in your relationship so you don't end up on the wrong side of these alarming statistics. Secondly, by following the motto that I apply to everything these days, which is preparing for the worst and then expecting and managing for the best right from the get-go, By agreeing to do a binding financial agreement with your partner, or what's commonly referred to as a cohabitation or prenuptial agreement, it's generally just referred to as a prenup. Now, it's important to stress that a binding financial agreement, or BFA prenup, isn't a sign of doubt. It's a sign of deep, unwavering care for each other's future. Because a binding financial agreement is about clarity and protection. It's about ensuring that if things don't go as planned, both of you are treated fairly. Now, when a marriage or long-term relationship dissolves without a BFA, emotions run high, and what was once a loving partnership can quickly turn into a nightmarish war zone. Financial ruin, legal wars, and years of trauma and resentment can follow. Now, think about it. Divorce rates remain significant, and when emotions take over, decisions get messy. And without a binding financial agreement, you're left to the mercy of the legal system, which often doesn't distribute assets in the way that aligns with your original intentions. Your hard-earned savings, your family inheritance, your investments and super, or even the business and career that you've built are likely to be at risk. And if children are involved, the financial toll is likely to ripple into their futures as well. But when you and your partner take the time to agree before the storms of life hit, you create a plan that safeguards both of you. A binding financial agreement doesn't mean you expect to fail. It means you're committed to fairness and respect no matter what happens. So when you're in love, this is the best time to protect one another. Don't wait until heartbreak clouds your judgment. Make big, important joint decisions when your hearts are full, not when they're broken. Because a BFA prenup isn't a plan for divorce, it's a plan for peace of mind. It's the gift of preparation. Because the strongest commitments aren't made blindly, they're built with love, honesty, and preparation. For me, a binding financial agreement is like an insurance policy to cover unexpected and unforeseen risks. And like insurance, you're likely to be sitting there nodding your head and agree with me on all of this, and then do absolutely nothing about it until it's too late. So I really challenge you to take the time to prepare a BFA now, and while you're at it, make sure you get your will done or update that as well. So how can you craft a binding financial agreement without creating unnecessary issues in your relationship while protecting your family's future? Because a common response from a partner when the subject of prenups is raised is, well, don't you trust me? Well, this is what we're going to dig into over the next 2 episodes with our very special guest, Ian Macleod from RP Emery and Associates. Because Ian's a seasoned professional with over 15 years plus of experience helping couples like you create legally binding agreements that define how finances will be treated before, during, and after their relationship, where he serves as a conduit between the legal and the non-legal worlds. Whether it's helping couples who are proactively protecting their assets from a future family law claim, or assisting those who have already agreed on a property division, Ian's focus remains on mutual agreement and keeping you out of court. Importantly, his approach prioritises avoiding the adversarial nature of the legal and family court systems, offering a more harmonious, efficient, and cost-effective alternative that preserves relationships and drastically reduces legal costs. So this week, we're going to dig into binding financial agreements when you're getting together and staying together, while next week, we're going to explore the ins and outs of BFAs for separations. So welcome, and let's get invested, eh?
G'day, Bushy. Thanks for having me.
Yeah, mate, they've been looking forward to this one because it's an area that doesn't get anywhere near enough focus, sadly, in the current world. But mate, I know you've been involved in this area quite some time. Sort of to kick things off, can you sort of give us a bit of a rundown on what you do differently and why you do what you do, please, mate?
Yeah. So let me first say that our business or our website, RP Emery and Associates, we are not a law firm. We are not a group of lawyers. We are a legal publishing service. And I personally am not a lawyer. I'm not legally trained, right? So I just want everybody to understand that. So don't take anything you get from me as legal advice. Legal advice is a personal thing. It's something that will come from a lawyer specific to your circumstances. What else would you like to know?
Well, I think probably the best way to set the tone, I think, and beyond that exercise, and that's an important distinction. And I think, you know, the world of legalese leaves people scratching their heads quite often. Having someone who can actually understand and interpret that and put them in layman's terms so that the average Joe like myself can actually understand what you're talking about is a big shift in the right direction. But I guess what I'd love to do now to sort of set the tone, if you like, Ian, is to get you to sort of take us back on your life journey so far and share with us where you've invested your time, energy, and money over the years and why, and how this has actually led you to where you are and what you're now doing.
Oh, okay. Well, we left it. How far back should I go? We left Sydney in 1993, and we moved to the north coast of New South Wales in a little town called Murwillumbah. And my background is that I'm a motor mechanic by trade, and I was sitting in bed one Saturday morning, and discontent with the life I had at that time. And my wife said, "Oh, what would you like to do?" I said, "I'd really like to own a little mechanical workshop in a small country town and buy and sell a few cars." And I opened the Sydney Morning Herald, and there was an ad there for a little business in a car yard, in a part of the world that I really love, and off we went. We bought that, and I did that for 15 years until my eyesight started to fail. I couldn't see things under the bonnet anymore. It was all just a little bit too hard. Around that time, my wife had been dabbling with a website of her own for many years that dealt with women's health, and I wanted to do something along the lines of, I wanted to get involved in the internet because it was fairly new area back then. So she started her first website in 1997. That's like the Stone Age, Anyway, I finished up buying this business from a chap where he used to send out coupons through the mail, through direct mail, for a CD that he was marketing. Right, it was 101 legal contracts on a compact disc. Right, and he'd each month he'd pick a town. Right, might be Kalgoorlie or so Perth or not necessarily Western Australia, of course, anywhere. All right, and he'd just go, "Oh, well, I'm going to hit that town this month," and he'd just send out a heap of letters, and people would respond and buy his CD. Well, we had I didn't know that much about legal contracts, but we knew a little bit about marketing, and we knew a little bit about the internet, and so we bought that and converted it to something that to a website where people could download each of those documents. And over the preceding, well, the next 12 months, we learnt what we'd actually bought, and there's a very steep learning curve about, making sure that those documents were all suitable for the Australian market and did what they were supposed to do and gave people the benefit that they were looking for. So anyway, that was 2006, and here we are, 25. So been doing it for quite some time now.
Yeah, I guess while you sort of mentioned that you're not a lawyer, I know, having sort of Google stalked your website, that you definitely got some partners that are lawyers.
We do.
If people are then looking to personalise exactly what they need to move things forward, protect themselves, then you've got that support happening behind the scenes. So that's I bet you've learned along that journey, mate, because it's a big shift from being in overalls underneath the car to talking about legal contracts in the area, and the work that you yourself and your wife have done. I'm sure that your knowledge on what they mean and what the benefits are have been pretty extensive, I would have thought.
Yeah. Look, it's like anything. It's the fear of the unknown, what you don't know. But as soon as once you know it, it's not so difficult, and it's not rocket science. Where some of the legal profession would like you to think it's really, really difficult, but it's not. Most of it, like when it comes to contracts, it's really about being clear and concise and putting into words what the provisions or the clauses, so they can't be misinterpreted. Right? And the best way to do that is use clear, plain English, this type of language that you and I would use, right? So it can't be misconstrued. Whereas, legalese over the years, it's confusing to most people because they don't understand the language. There was a time once where lawyers were paid by the word, right? So are paid by the word for a contract. That's why you have, the sentences that, like
go on forever.
Incredibly, but go on forever, right? Where you could have said the same thing in, half a dozen words instead of 27, so anyway.
And that's exactly why we've got you on, because everything and the world of property is no different. People like to make it sound way more complicated than it is, but it ain't rocket science. If you follow simple things and you cut to the chase, then it's a lot easier and more beneficial to everyone. Before we sort of jump into that world of BFAs in a bit more detail, though, and if we look back on your journey so far, what sort of challenging event in your life has brought you the biggest learnings and best changes, do you think?
One has to take a risk every now and again, but you also have to have a bit of confidence. You need to have a bit of confidence in yourself and what you can do and what can be achieved, and you need to balance that with the risk, I suppose. Like when we bought that, I was a lot younger, had a little more in front of me, I suppose. But when we bought that business, man, the drive home in the car with a website on a CD and a printer in the back seat for what was going to be the money to renovate our house. That was the scary moment.
But what gave you because you're absolutely right, because a lot of people put themselves in their own prison cages by allowing their own thoughts and limitations to get in the way of an opportunity. And then let's be honest, there's a significant jump from being a mechanic to driving a website that sells contracts. What gave you that confidence, do you think, to take that leap off the cliff?
Look, along the way, look, I have had a bit of sales training in my life, okay, and I have confidence in my ability to convey a message. And one of the teachers I had I remember this little anecdote, this story that he told me, was in relation to a commission-only job that I was about to embark on, and he was doing the training. And he said to me, he said, do you know how they catch spider monkeys in the bush? No, he said, they take a jar, like a big jar with a little narrow neck, and they put a bit of fruit in the bottom of the jar. The little spider monkey comes along and he grabs the fruit. He's got it in his hand, but he's got it clenched, but it can't come out through the neck of the bottle. All right. And that's like that fruit is his next meal. That's his security, but he won't let go of it for his own freedom. All right. And they just come along and pick him up off the ground, and away they go. And that was a valuable lesson. You've got to be prepared to let go of your security to gain what you really want in life.
It's a great analogy, mate. Again, a little bit of a segue here if we can, because, what we're about to talk about with relationships and that side of the equation, they all revolve around trust, as I spoke briefly about in the green room before we hit the record button. But what does trust mean to you?
It's incredibly important. Trust is all we have, in our business relationships, in our family. Once if you betray the trust of a partner, for instance, it's just never going to be the same. Once you break that trust in your personal relationships, they just collapse, really. And the same goes for business relationships, and particularly in today's world, in business, you cannot afford to betray somebody's trust, because the ramifications of that are just horrendous. Social media. We used to say, somebody's bad mouthing you around town or whatever, right? They might only have a few small friends, all right. But these days, people have huge personal audiences, and you just can't afford to.
Absolutely,
you just can't afford to do it.
Yeah, no, absolutely agree. Now let's jump into the meat and potatoes of the chat.
Sure.
Because what I mentioned in the intro, I know enough to be dangerous about binding financial agreements. That's
you brought up some really good points in relation to the risks and the cold hard statistics of one in 4 marriages failing within a 10-year period. And one of the things that I often, people say to me, should I get a binding financial agreement? Well, it's not, like asking me that is like asking a barber if you need a haircut, So don't ask me. Or is it a good time to sell real estate?
That's exactly right. Well, let's jump into BFAs for a second. And again, with it, because assumption is a very dangerous thing. So to get it from the horse's mouth, so to speak, what is a binding financial agreement, and what is its purpose under the family? Okay. If you can spell that out.
Okay. Binding financial agreements were established under the Family Law Act, I think somewhere around about early 2000s, 2001, 2002, something like that. And they're essentially a contract between the parties that says, look, if our relationship were to fail, this is how we want our property divided. And I should point out that you can make a binding financial agreement before, during, or after a marriage or a relationship has ended, right? So, it's an umbrella term for things like, you might term a cohabitation agreement, or a prenuptial agreement, or a postnuptial agreement, or a separation agreement. Right? So it can be made at any time. So, but if you're talking about, say, during a de facto relationship, right? So a BFA will set out how your property, your assets and liabilities should be divided in the event that relationship were to come to an end. Yeah. I should put out the primary purpose of that, of introducing BFAs, was to relieve the pressure on the family court, because you've got, separations are a part of life, and people move into relationships and out of relationships all the time. And for the ones that get messy, that finish up before the family courts just can't take the load. There's just too much, right? And so binding financial agreements were introduced so people can work things out themselves. Yeah. And hopefully they will be able to work things out themselves. So an agreement made before a marriage, a prenuptial agreement, will set out what happens if my marriage fails, all right? And it actually closes the door to the family court. So once that agreement is in place, you cannot bring an action in the family court in relation to the subject matter of that contract.
That's really interesting. Okay, I wasn't aware of that. So that's what that really reinforces is the need to get those BFAs right and make sure that both parties are very happy with what you're signing off on, because that's your one roll of the dice, pretty much in that context. Then,
yeah,
yeah, okay.
It is crucial that you do get it right, because you must have genuine agreement. You can't have one party saying, "Oh, look, I want to get this thing done. I want to get it done," and the other party going, "Well, you do whatever you want to do. I'll sign anything." All right, that's not genuine agreement. That's coercion. That's duress. All right, and consequently, before a binding financial agreement has any binding effect, both parties must receive legal advice about their rights, what rights they give up, and whether or not signing that agreement is to your advantage or to your disadvantage.
God. So are there any other legal requirements around that needs to be met for a BFA to be valid and enforceable?
Well, yeah, essentially the lawyer who provides that advice must issue a certificate that says they've provided that advice. The agreement must be signed. It's got to be signed by both parties in front of a credible witness. We recommend you use the JP. And there just can't be any whiff of duress, coercion, unconscionable conduct, which is essentially taking advantage of the other party's ignorance, fraud. So these are elements that an agreement, a binding financial agreement, can be set aside by the court. So even though while that agreement's in force, you cannot bring an action in the family court in relation to what's in there, but you can attempt to have that agreement set aside. All right, it can be challenged, but in order for it to be challenged, you have to establish that there was, some sort of fraud, some sort of coercion, non-disclosure of a material matter. Non-disclosure of a material matter is something that is relevant to the other party's decision as to whether they enter that agreement or not. Like, for instance, you might say, look, I own this house and I've got some super and I've got an investment property or whatever.
Yeah.
All right. Am I right? And you're asking the other party to give up their right to make a claim against that, but you just happen to ignore the fact that your great uncle Harry just died, and you're likely to inherit $10 million or something. That might change that party's decision to enter that agreement. Right? So if you hide something or you're not totally honest, then you weaken the foundations of that agreement.
Yes. Yeah.
Does that make sense?
Yeah, it does. There's a fair bit of grey area in that, though. So I'm guessing that there's probably quite a few people, given that circumstances change over time, that would try and overturn a BFA.
Oh yeah, they try to, and sometimes people have, and there are instances where those agreements have been set aside by the courts, but generally it's because one party hasn't been honest with the other. They've tried to mislead the other, or they've tried to do something shonky. Like one of the things that people often do is, they want to put a prenuptial agreement. I'm getting married next month. I need to get a prenuptial agreement put in place. All right. So you can imagine a situation where, all right, so next month the wedding's already planned. They've spent $10,000 on the caterer. They've spent $20,000 on the venue. You've got people coming from all over Australia. I don't know, 250 guests. All right. And then one party puts a document in front of the other and says, here, we've got to get this signed before the wedding. It's hardly like the weaker party has any choice. Yeah. they're under pressure, because it might be inferred that, well, if we don't get this thing signed, the wedding's off.
Yeah.
And so, there's things that you need to do to mitigate that risk.
Yeah.
Right. And there've been cases in the past where the courts have set agreements aside where they've been made under those sorts of circumstances. And people think, oh yeah, but if she agrees, that's okay. We just do that. No, genuine agreement is the key. Not try to hoodwink the other party or put them under pressure or put them in a situation where they have no choice. That's not genuine agreement.
Yeah, got it. No, that's brilliant. So once a BFA is actually in place, what does it actually do?
Well, like I said previously, it closes the door to the family court, right? So you cannot bring an action into the family court about the division of property because you've already covered that yourself in this agreement.
Yeah.
Okay. So that's it. That is its intention.
Yeah.
To close the door to the family court, and rather than running off to a lawyer to figure out how things should be divided, it should all be in that document, and it should still be relatively fair. And if the parties have got genuine agreement, that shouldn't be a question.
Yeah, absolutely. And certainly massive savings in time, money, heartache, stress, pain. I tell you firsthand, having been through it, I was lucky. I had a lawyer who said, look, he said to me and my now ex-wife, he said, look, you can keep fighting this, and every cent that you're looking to agree between you will end up in our pockets, or you can get sensible about it, and here's a reasonable and fair position for both of you.
Yes,
you accept it. That was the best advice he'd ever given.
It was, yeah. That was really good advice, because I know people like to badmouth lawyers, and they're not all bad. I've got lawyers that I work with who are just some of the most wonderful people. But what people tend to do is, the relationship breaks down, and they run off to find a lawyer. He runs off to find his lawyer, and she runs off to find hers, and then they start sending curt emails to each other. All right, and it just inflames the situation. It just makes things worse. Whereas and I know this is probably a bit idealistic, and I'm lucky I've been married for 35 years. I haven't had to go through it, right? So I haven't experienced it personally. I've just sat on the sidelines and seen it happen time and time again. But if people can just remember that, there was some good in the other party, and try to keep those lines of communication open between yourselves, rather than going out and hiring a sellsword, which is what it's like you want somebody to go out and slay the dragon for you. Rather than taking that approach, try to do your negotiation yourself. And if you can't do it yourself, don't do it through the lawyers. Go and find a counsellor, find somebody who can help you through mediation. All right. So you can get a perspective of the other party's circumstances, and maybe a little bit of empathy towards them, and maybe they can have a bit more empathy towards you. And so keep the lawyers out of it until you actually need them.
Yes. Yeah, just to fill in the final paperwork, basically. Yeah, no, I love that. I touched on marriage and de factos in the intro, and it's pretty obvious that marriage is on decline and de factos are on the increase. Are there any differences in considerations and treatments in relation to BFAs and related matters between marriages and relationships?
So maybe look at the differences within the classification of whether somebody's in a de facto relationship or, like you're married. If you're married, you've gone through the ceremony, you've got the certificate, and somebody put a signature on. You've signed the marriage contract. You are married, right? Yeah. Whereas people, you come together, you like each other's company, all right, and you might spend a night at your partner's residence once a week. Then it becomes 2 days, then 3, all right, and you're slowly becoming closer and closer and closer, and then it's, well, we'll spend three nights at my place, and then 4 nights at your place, and so all of a sudden you're in this relationship, which, even though you might still have separate residences, you're spending every night together. All right. And then it can become a bit grey, right? Are you in a de facto relationship? Are you not in a de facto relationship? And when you decide to get married, you make that decision, fairly consciously. But with a de facto relationship, people sometimes they just blend and they hang on. Oh, hey, presto, I'm in this relationship. All right. I'm in a de facto relationship. And once you've been in that de facto relationship for 2 years.
2 years, okay.
2 years. And it's difficult to determine, like, when did that start, right? That's the grey area. But once you've been in that relationship for 2 years, then either party gains the right to ask the court to make orders for the division of property, right? So all of a sudden, you have exactly the same rights as a married couple. There's no conceivable difference. Now, there are a couple of exceptions to that 2-year rule. If you register the relationship, because like people will often they want to bring a bride in from overseas, and part of that partnership process is you've got to register that relationship. Once you register that relationship, well, that 2-year period's out the door. Doesn't matter anymore. If you have a child together, that 2-year period goes out the door. Yeah. So, all right.
Yeah, it makes perfect sense. Well, sort of taking that on board now, and from what you've said, it's even more important for someone in a de facto to get a BFA, because they may be in a relationship without even realising it. So from where I sit, there's bigger risks with that than there is with marriage, because there's a very clear line in the sand with the marriage, where it's not. It's a bit blurry on the de facto side. But sort of moving now into the sort of ongoing relationship side of the equation with that, jumping forward a little bit, how did BFAs affect estate planning and inheritance?
They can form part of estate planning, but you've got to remember, that the purpose of the BFA is to set out how your property should be divided if the relationship fails. It's not what happens if you die. Yeah. All right. Because if you pass away, your will has precedence. Yeah. All right. But if you do pass away and you have a BFA in place, that BFA has to be followed. The executor of your estate has to follow that BFA as if you were still around, right? So that the executor has to stand in your shoes. So if under that BFA you said, all right, I don't know, it's a little bit difficult, when these two things are starting to blur. But you can have, we quite often have older couples who want the BFA in place so they can draw a very clear line that the purpose of this document is I want to protect my property for the benefit of my children. Yeah. Right, from a previous relationship. And so the BFA can make that very clear that the reason we want this BFA in place is to protect my property for the benefit of my children in the event if this relationship were to fail. And so that can be used to reinforce what you might have set out in your will.
Got it. Yeah, no, that makes perfect. So that's just about kids, and that's an important one I think you've raised. Can a BFA include rules around spousal maintenance, and if so, how does that usually work?
Generally, look, usually it works that if you've got two people who are both working, they're able to support themselves. Generally speaking, the BFA will say that, I'm not going to pay you spousal maintenance and you're not going to pay me anything. Yeah. However, you might have one partner who cannot support themselves for whatever reason. They might have a disability or whatever. And then so maybe the wealthier party may say in the BFA that in the event if we break down, I'm going to pay you X amount for a certain period of time. All right. But if you get into a new relationship, well, I don't have to pay that anymore. Or if you remarry, we won't have to pay that anymore. If I fall off the twig, my estate doesn't have to pay that anymore. Yeah. Right. So you can set into the document some triggers, right, that say I'm going to pay under these circumstances and I'm not going to pay under these.
Yeah, no, that makes perfect sense. So there's a fair bit involved here, and getting it right is pretty important. So what sort of common mistakes should people avoid when they're drafting a BFA? Eh?
The most common one we see is non-disclosure. All right, so people don't disclose their assets, or they'll say, "Oh, look, we've just decided between ourselves that I don't need to know what she's got, and she doesn't need to know what I've got." But we're going to, but the agreement is going to say I have no entitlement to her stuff, and she has no entitlement to my stuff. So under the law, you cannot give up your right to something unless you know what it is.
Yeah.
Right. So you can't say I don't have any right to any of his stuff or his Uncle Harry's inheritance or whatever the case may be unless you know about it. Right. So you have to make full and frank disclosure to each other for a couple of reasons. One, so you know what you're giving up your right to, if you have a right to whatever it is. Yeah. And the other is when the lawyers provide your legal advice, they have to advise you whether or not signing that agreement is it to your advantage or to your disadvantage. Yep. Now, without a full understanding of that property pool, they can't provide that advice. Cool. How do they know? How do they know if it's to your advantage or not without an understanding of what's there?
Yeah. Yeah, makes sense.
Yeah.
Let's jump into the investor box for a minute, because that a lot of our us listening in to you today are active in the investment space and or might be business owners or looking to do that. How can BFAs be used to protect assets in either investment assets or business assets in that context?
Oh, well. Like if you've got I don't know, you've got a hairdressing business or you've got an engineering business or you're a consultant or whatever the case may be, you can define that business as your separate property, just like you do a bank account. All right. So if you've got a bank account in your name, it's your separate property. If you've got your superannuation is your separate property. Your investment properties, which are in your name alone, are your separate property. And if you've got a business, a company, a trust, a self-managed super fund, whatever, you just have to set those out. You identify that particular asset in your assets and liabilities statement when you're drafting the agreement, and you identify it as your separate property. So in our documents, we have two specifically defined terms: separate property and joint property. So joint property is anything that cannot be defined as separate property.
Yep.
Or if it's property that's in joint names. So you might come into the relationship and you say, all right, well, I've bought this is my property portfolio of whatever, and this is my business, and this is my Land Rover, and you've got your hairdressing business. But we might buy something together. We might buy an investment property, or we might buy a family home together. And so you simply purchase that property, and on the title, you can either buy it in as joint tenants or tenants in common in equal shares or unequal shares, whatever the case may be. But whatever it says on the title, that's how that property would be divided in the event if the whole thing turned to custard.
Yeah. Yeah. Well, here's an interesting one because, my impression was let's say a couple decides for asset protection purposes that the person who owns and runs a business doesn't appear on the title and the other party does, because that means if something happens to the business, no one can go after them because their assets are held in the other party. Yeah, does that need to be instituted within the BFA, or does that expose the party who's not on the title to the risk of not being considered with that?
If you, oh no, look, I just need to think about it a bit. Look, if you're saying you've got an interest in a property, or you've got an interest in a business, but it's not actually documented anywhere, all right? You can still set it out in the BFA, and you might say, well, I've got, quite often people will have, it might be a property that one party owns, and the other party coming into the relationship wants to buy a piece of that. Yeah. All right. So let's say it might be a $1 million property, and the partner wants to put in $500,000 and own half. Well, the first thing that happens there is you've got to pay stamp duty on 500.
Change of ownership, exactly.
If you want to change of ownership, yeah. So, that's one impost. But that also depends on what state you're in. Some like in Victoria, I think the rules are a little bit easier. I think you can still do that if you can just make a declaration that you're spouse partners. But the rules vary from state to state. But let's say for argument's sake, that the title is going to stay in the original name of the original owner, but you can set out in the BFA that, hey, my partner put in, $500,000, and she has a 50% interest in that property. Yeah. All right. So even though it might not be reflected on the title, you can still set it out in the BFA that this is the circumstance.
Yeah, no, it makes perfect sense. Awesome.
Makes sense.
So the one thing that does happen a lot in life is change, and circumstances change time with kids or shifts in financial positions. What happens with BFAs in that context?
More specific. Give me a more specific
so
thing to work with.
Yeah, yes. Okay, man, that's perfect. So a couple get together, don't have any kids. Time they've got 3 kids.
Yes.
BFA that they put together when they got together, they weren't going to have kids, but now they do. Does the BFA need to be amended or changed, or how is that?
It doesn't necessarily mean that the BFA is null and void just because you have kids. All right. Yeah. However, if you're planning to have kids, well, we would make sure you set out in that document, say, look, we're planning to have kids, all right? And if we do have kids, we want this agreement to stand. We don't want it to be, the arrival of kids will be a joy and something we welcome and something we're looking forward to. It doesn't necessarily mean that this agreement should be set aside. However, with a younger couple, where it's quite likely children will come along and their life circumstances will change, it's recommended that you review that document from time to time, just like you do a will. Yeah. Much like ourselves, these documents are strong when they're young. All right? All right?
I like that, strong when they're young.
They're strong when they're young. All right. But as time goes on and life circumstances change, they will become weaker. So, like if you put an agreement in place today and you need to rely on that document in, say, 15 years' time, I'm not trying to say, look, that they're worthless. What I'm trying to say is that you need to be aware that circumstances will change. There could be changes to the law. There could be changes to the Family Law Act. There could be changes to case law, because as time goes on, there will be matters that come before the court where the court make decisions and say, well, this agreement is going to be set aside because of these reasons, right? And we don't know. Nobody's got a crystal ball, right? So the longer the time period between when you put that agreement in place and when maybe you have to rely on it, the weaker it's going to be. So if you're trying to enforce something in 15 years' time, it might still stand up, but who knows? And I'm not saying it won't. It may well do, but it might be a bit more difficult to enforce that agreement at that time. So the current thinking is that treat it like your will. As your life circumstances change from time to time, you might just go back and say, let's look at this again. And let's update it to our circumstances as our circumstances are today, particularly if you've had, 3 more kids and you've got two investment properties in one partner's name and 3 jointly, who knows? Who knows how things are going to roll? There could be life circumstances around, there could be health issues where one partner becomes the carer for the other. Yep. And then maybe that agreement's going to be totally unfair. Who knows? Yep. Just take those circumstances into account and review the document every, like we generally say between 5 and 10 years.
Yeah, right? Makes sense.
Once you get over about 10 years, you start to stretch things out a little.
Yeah, no, beautifully said. What are some of the most, for those that are listening and going, I really need to get my teeth into this. What are the most helpful resources that we can access on the subject of BFAs?
Oh, me.
Well, let's talk about that. How can you actually help people put a financial agreement in place? It's probably the right time to ask that.
All right. So as I mentioned before, we've got RP Emery and Associates, and through that website, but we also have financialagreements.com.au and peacefulpath.com.au. They're all websites that all lead back to us. It's still the same products, just a different marketing message. But so you can purchase a kit through the website, read the instructions, because that'll give you the information you need. And then there's a sample agreement in the kit and a template agreement. So you would fill out that template agreement, and when you're confident, and do it with your partner. Don't just fill it out yourself and then hand her a copy or him a copy and say, yeah, this is what I want to do. Have the discussion first. Have the talk first before you even go and download anything. All right. Talk about your insecurities, why you want to put this agreement in place, and then buy the kit and follow the instructions. I might point out too, like one of the people do feel insecure.
Yeah,
right? Those insecurities will rise up, and like sometimes people go, but if we separate, I'm going to lose what I've built up here, and and that can cause tensions in the relationship. Yeah. Whereas if you recognize that is causing a problem, if it is, right, then you can put an agreement in place that might just put those issues to bed. Exactly. And then you can just sort of live happily ever after. And hopefully you never have to use that agreement at all. Hopefully it just goes in a bottom drawer and you never have to refer to it again, except maybe, review it every now and again.
Yeah.
All right. So you would use the kit, and once you've got a draft agreement, you send it back to me. I've I've got a relationship with 5 lawyers who are happy to provide the legal advice in relation to a document that you've drafted from our kit, as long as you send it back to us first. So, and when I say us, I mean me.
Yeah.
So I have to prepare that document for the lawyers so they can work through it quickly and efficiently. Yeah. So they don't have to spend as much time redrafting clauses or requesting information from you. So that's what I do. I will make sure that document reflects your wishes before it actually gets to the lawyers, right? And then the lawyers will provide their legal advice. And these lawyers are independent of us and independent of each other. So I've got 2 in Victoria, 2 family law specialists in Victoria. I've got another one in Sydney and 2 here on the north coast of New South Wales where I live. And they all run their own little law firms.
Yep.
All right. Except for one guy, he heads up the family law department in a mid-tier law firm. Yep. And we've done thousands of them. Yeah. Literally thousands of them.
Yeah.
At
a fraction
I'm tempted to say we haven't had. I'm tempted to say we haven't had one challenged yet. So, but eventually it'll happen. Sometime it will.
Oh yeah. No, and that's really good. I think what I love about what I'm hearing, Ian, is the common sense, down to earth approach that you bring to the table that really enables couples to work through the stuff in a language that everyone can understand, and then the lawyers pretty much just formalise it at the end to make sure that the protections. So
no. Let me just pull you up there. Their job is to provide that legal advice as if I didn't exist. All right, I might prepare the customer for their interaction with a lawyer, and I might cover some of their questions, but I can't provide legal advice.
No.
And the lawyers that we do is far more than a rubber stamp. If anybody comes to us and they're expected a rubber stamp on their document, go somewhere else, because it won't happen. The lawyers are very much just like any other conscientious lawyer who wants to act in the best interest of their client. Yeah. And so, if they're presented with a document that provides a significant disadvantage to their client, they will point that out. Right? They'll in no uncertain terms, both verbally and in writing, right? And they may say, look, I recommend you don't sign that agreement, right? Now, having said that, at the end of the day, it's really up to the client with the knowledge that they've received from their lawyer as to whether they sign that agreement or not, right? Maybe they go back to the negotiating table with their partner, right, and see if they can negotiate a better deal. And their lawyer might give them some examples of how you might get a better outcome, right, if the agreement's too lopsided. So, they are far from a rubber stamp service, and I do take not offence to your words, but sometimes people think that I'll just get the lawyer will just sign off on it. No, they do not. They do not just sign off on it. Yeah. They spend a great deal of time in consultation first to discuss the ramifications of signing that agreement, right? And they'll give the client that advice verbally and in writing, as you would expect if you went to any other family law firm who knows what they're doing.
Yes.
All right.
Yeah. No. Well said. I'm glad I said that the way I did, because that's forced you to clarify that, and it's a very important distinction be made on that. Now, we've only just scratched the surface, and we're going to dive into more details of it in the next episode. But so I just want to sort of thank you for taking the time to open our eyes to the clear benefits of binding financial agreements so far, Ian. Before we go, if anyone listening would like to explore this further and how property can work better for you in the context of what you're doing, feel free to book in with me for a personal solution session by clicking the link in the show notes. We now look forward to continuing our conversation with Ian in next week's episode, where we're going to explore the ins and outs of binding financial agreements for separations. So remember to always get invested in your knowledge and your network before you invest in assets. And we look forward to getting invested with you again then, Ian.
Thanks, Bushy. It's been a pleasure.
Thanks for tuning in to Get Invested on the Property Hub podcast channel, your home for property investment insights and inspiration. Make sure you subscribe to Property Hub for free. Get your weekly dose of Get Invested inspiration along with every episode of Realty Talk, Australia's top online property show for red-hot property investing news and insights direct from industry leaders and influencers. And finally, I'll see you next time.